part-heard appeal in the matter of Riley and another, and National Westminster Bank PLC.
Mr. Sinclair, before you get going, two things, one administrative and one more substantive. Administrative, it was pretty hot here yesterday. Apparently this court is notoriously hot, and it's not easy to make it cooler. We are thinking about seeing whether another court might be available for this afternoon. It would not be a court where there is live stream, provided that neither Mr. nor Mrs. Riley was planning to view on live stream, or anybody else who plays an essential part in the story. It doesn't seem to me that there would be anything wrong with moving to another court, even if there is no live stream. Better that we should all be in a court with a reasonable temperature. Mr. Sims, do you see any problem as to that?
I don't. I'm aware that one of the family members, I think, has been watching live stream, but I'm not sure if they're necessarily fall into the category you've identified.
No.
And I can see that the desirability of having a cooler temperature probably is the most important thing, because it certainly was hot.
I think
so I'll take instructions, but subject to those instructions, I understand the court's concern.
And the more substantive thing, Mr. Sinclair, is we have discussed the case overnight. We need not hear you on grounds 1 to 4. So we'd like you to continue with ground 5 and then come on to the cross-appeal on limitation in due course.
Thank you, my lord, and thank you. So, dealing with ground 5, I was going to turn to the Siddiqui, Kazimi, Nini, and Siddiqui case, which is at Authorities tab 16. We would make a preliminary observation about this case, which is that this case doesn't purport to set out any general principles. It's merely an example, an exercise of contractual construction in a particular factual context. And so it doesn't offer much by the way of precedent to your lordships, but it's nevertheless striking, we say, because of the substantial differences from our case. And your lordships are familiar, I think, with the case itself, so I won't take you through that. But in terms of the differences, we rely on 4. Firstly, Mr. Grano had his own entirely separate claim from Mr. Casamini. So some of those claims did arise under a tripartite agreement, but they were nevertheless his own claims under that agreement for his own investments of a sum of money, independent of a different sum of money that Mr. Casamini had invested. So Mr. Grano had entirely separate claims, even under the tripartite agreement. But as is, I think, clear from paragraph 10 of the judgment, about 5 lines down, 6 lines down, it says, although there are separate claims to recover loans alleged to have been made to Mr. Siddiqui and his companies. So some of the claims are based on the same agreement, but there were also claims that Mr. Grano had under the separate claims to recover loans under separate agreements, it seems.
But I mean, okay, but in A, there are some claims which are the same, actually the same, to transfer, particularly to transfer the interests to Mr. Casamini. And in the instant case, RHL's claims are distinct from the claims of the Mr. and Mrs. Riley. I mean, they are legally distinct claims.
Certainly, they're legally distinct claims, that's true, but they overlap almost entirely. factually, in terms of the claim is about the claim that the Rileys have are, as Mr. Sims explained, in their character as employees and shareholders and that sort of thing.
No,
And
I don't think so. I mean, they're as I understood it, well, sorry, the primary wrong is said to have been done to RHL by the destruction of its business. True it is that the claims are then asserted by Mr. and Mrs. Riley in their capacity, the only two capacities they have, which is as either employees or shareholders. But the claims do not legally overlap because of the rule against reflective loss.
no, I accept that. I accept that. So I accept that. So in order to have sustainable claims by the Rileys, they must be legally distinct because of the rule on reflective loss. So we proceed on the assumption they have legally distinct claims from RHL, that's right. But they are closely tied together, factually. There's a factual overlap in a different way to the way Mr. Grano, who may be party to a let's just take the situation of the tripartite loans. He has loaned some money under a certain agreement. Mr. Siddiqui has loaned some money under a certain agreement. They have separate claims. They may have some connection as well, factually, but they are entirely separate claims for money I am loaned under an agreement and money he is loaned under an agreement.
Well, that part of the claim is separate, but there was a claim for transfer of the shares, which is identified in paragraph 10, which is not dependent upon the loans, as I understand it. In the second sentence of paragraph 10 of the judgment, in particular, in each case a claim is made under the tripart agreement to compel Mr. Siddiqui to transfer an interest in certain of his companies to Mr. Casimini. I mean, that's not a loan. That's not based on the separate loan.
I can see that. I mean, we're slightly stymied by not knowing all the facts of this case. But I assume that Mr. Grano also had a claim to transfer a similar interest in maybe even the same companies to himself. But again, though that is a claim for other shares in the same, albeit in the same company, he's not asking for the same shares to be transferred to him, one assumes. So they each have a claim to get this packet of shares or that packet of shares or repayment of this loan or that loan. So they may well have parallel claims that have some factual similarities, but they are completely distinct claims, obviously. Whereas, and I accept the RHL has a completely legally distinct claim from the Rileys, but not in the same way, that they overlap in a way that, for example, if one imagines the pleadings in the Siddiqui and Casimini case, Mr. Casimini will be talking about things that were done to him, his interests, his loans, his causes of action, and Mr. Grano will be doing the same about his own claims. Whereas in the Riley case, the Rileys are saying, look what you did to RHL, therefore we have a claim. And so there is a measure of overlap, which is different in our submission to the Grano-Casimini overlap, where there is a similarity of facts, but not an overlap in the same way, we will say. So
has anybody on either side looked for or managed to find the judgment of Mr. Justice Flo from which this unreported transcript was the appeal?
I don't think we have.
I did try a search and wasn't able to identify it.
So, my lord, that's our first point of distinction. Our second point of distinction is that the settlement agreement in that case, which we see in paragraph 3 of the judgment, had the important words in the description of the content of what was being settled, or by any person whatsoever. So any dealings between the parties concerning loans to, or investments in the defendants by the claimants or by any person whatsoever. And it was those words which were being relied on as saying, well, those cover Mr. Grano as well. And at paragraph 12 of the judgment, the Court of Appeal concluded that using the words by any person whatsoever were too oblique to refer to Mr. Grano, and that, in fact, they referred to something which was called the friends and family claim instead. But in our case, we say that clause 7 of the assessment agreement, which I expect your lordships can turn up, but is at core bundle tab 11, page 275, doesn't use that sort of oblique language, but instead says any claims arising out of or in connection with Riley Holdings. So there's no obliqueness. It's an express reference in our case. And if one imagined in the Siddiqui case that the language of the settlement agreement...
Hang on, sorry, excuse me. So I don't want to keep interrupting, but you're comparing apples and pears.
Right.
In this case, there was specific language identifying the subject matter of MetroCab. It's the preceding words concerning loans to or investments in the defendants or FNT or MetroCab. Surely that's the equivalent to your point that in our current case, there's a reference to RHL, etc. I mean, one's dealing with the subject matter, the corporate subject matter. Isn't there a direct similarity between the two clauses in that respect? I mean, surely those are the two. That's the comparator.
I can see that, but I'm not sure that we would agree with that, my lord. I mean, there are two subject matter definitions, I suppose, in the Casamini definition, that it's to do with claims against the defendants or MetroCab or FNT. Except that that's just identifying the party to the claim,
no.
Isn't it? So full and final assessments of all claims that the claimants have or may have against the defendants or to other companies.
No.
Sorry.
I thought you were drawing a distinction that in our case you were saying, look, unless I misheard you, I misunderstood your submission. Apologies if I did, but you were saying in our particular clause 7.1 there are specific references to arising out of or in connection with, and then 3 identified subject matters.
Yes.
I.e. the facility agreements, the personal guarantee or the legal charge, NDA or Riley Holdings, or properties formerly owned by Riley Holdings.
Yes.
Those are the subject matters. You're saying that's specific in our case.
Yes.
Well, why isn't that reflected in the same way that here it's any claims that the claimants may have against the defendants, etc., arising out of or in any way connected with proceedings, either identified proceedings or with any dealings between the parties concerning loans to or investments in the defendants or FNT or MetroCab by the claimants, or by any, it's identifying the corporate subject matter of the dispute in the same way, isn't it?
I think what would be the same way would be if it also said, or any dealings by Mr. Grano, wouldn't it? That would be the analogy. Would be if the assessment agreement specifically says we're ruling out any claims you have arising out of dealings between the parties concerning various things, including Mr. Grano.
Well, you say that all by any person on the face of it includes Mr. Grano.
Well, it would do. That was the argument that they tried to run, and the Court of Appeal said no. It's too oblique to refer. It refers to something else. We're looking at the context. All by any person actually has a meaning, which is the friends and family claim. So it serves a function, that phrase, but it doesn't include Mr. Grano. Whereas if instead of saying all by any person whatsoever, it had said by Mr. Grano, or if it had said by any person including Mr. Grano, or if the subject matter had referred expressly to Mr. Grano, then no one would have been able to complain that the generality of the clause on its face was too oblique to include Mr. Grano.
But one might take the view that the wording in this case is more oblique, because on the face of it, or by any person, is an express reference to other investors, which would encompass Mr. Grano, though it doesn't say so.
Yes, but...
Whereas in the present case, what it doesn't refer to is RHL's claims.
Yes, but, well, it refers to any claim arising from or out of, in connection with Riley RHL.
Yeah.
So
It doesn't say
not,
RHL's claims.
No, that's right, because it's not...
It's not anticipating an assignment.
No, well, no,
It's the problem, isn't it?
I don't know that is the problem.
Well, that's the issue.
I don't know about that, my lord, because because I think this is defining the subject matter of the and the subject. In other words, what is the claim about? And so, rather than to whom does the claim belong, or who is the party bringing the claim, or in what capacity are they bringing it? That's none of that subject matter. The subject matter is what is the factual underlying cause of the claim, and that very expressly covers Riley Holdings. Yeah. Whereas in Grano, there was a wide extension by saying the claimants or by any other any person whatsoever, which is apt to suggest it's covering other investors. And the answer the Court of Appeal said, yes, it does cover other investors. It's the friends and family claim. But it was not apt to cover Mr. Grano. Whereas if it had said Mr. Grano, then I would suggest, it's obvious, the Court of Appeal would have come out differently. And in our case, it does say RHL.
Well, you say, as we went through yesterday, on a very straightforward reading, that these are claims which are that hereafter Mr. Riley has against the bank in connection with Riley Holdings.
Exactly. So yes, and although the Court of Appeal accepted, I think, in Siddiqui, that also the wording of Clause 5, just reading it, was apt to cover the Grano claims.
Yeah.
One reads it in context, and they say, actually, it's not as wide as you might think, because that wide bit is talking about the friends and family claims. And if they had wanted to talk about Mr. Grano, well, they don't say it, but I say, if they'd wanted to talk about Mr. Grano, they should have written it down, in which case, that wouldn't be an oblique reference. So, my lords, that we say is an important distinction with our case. And the third, I think I said I have 4 reasons. I have 3 reasons. And my third distinction from Siddiqui is that there is no clause point 7.2 in Siddiqui, which we say puts any nice contractual interpretation questions out of the question, really, because it becomes plain by clause 7.2 that Mr. Riley has agreed. This is as I said yesterday, the heading to 7 is a covenant not to sue, and it's a release. So we've been looking at the release at 7.1. Number 7.2 is a covenant not to sue. Mr. Riley has agreed he will not sue the bank. And so he has agreed he will not bring any proceedings whatsoever against the bank in any way connected with released claims. Whereas, if it had been said in Siddiqui that Mr. Casamini had given a covenant not to bring any further proceedings or any proceedings against Mr. Siddiqui arising out of in any way these or any connections to these claims, then that would have been a strong argument, we say, in favour of the clause covering the Grano claims.
But the key words, as my Lord has put to you, in our clause 7.1 are, as we're beginning to identify, claims that it may have or hereafter shall or may have. I mean, those are the words we've been focusing on. I mean, those are the same words that appear in the relevant release in, give or take, all claims that the claimants have or may have against.
Yes.
And yet those words were not thought to carry the day in Casamino.
Well, those words would have been fine if the subject matter had covered the Grano claims. I think I think this was a discussion that was.
The Grano claims are clearly caught by the remainder of the clause 5 in Casamini, because the Court of Appeal say in paragraph 10 of the judgment, the claims being made in the present proceedings are closely connected with the previous proceedings and the dealings between the parties out of which they arose. I mean, that's because it's the first bit of the clause. They are clearly saying the subject matter of the claims does fall within the clause because they are connected with the previous proceedings, i.e. arising under or in any way connected with parts A and B in the counterclaim in the commercial court proceedings. So the Court of Appeal is not, in Casamini, is not drawing any distinction based upon the words you're trying to get us to focus on. They're saying, look, these did fall within, or they would fall within the second bit of the in any way connected with, i.e. the middle bit of that clause, not the last bit you're trying to get us to focus on, or with any other dealings. But they say, notwithstanding the fact that it talks about claims that the claimants have or may have, that doesn't amount to a settlement.
Well, my Lord, I'm not sure about that. I think what the Court of Appeal is saying in paragraph 10 is that because there's a connection, in that respect, so 4 lines up from the bottom, page 633, in that respect, therefore, it can certainly be said that the claims being made in the present proceedings are closely connected. However, and then they refer to ECCI, the true scope of the settlement agreement can be determined only by reference to the context in which it's made. So, and then having reviewed the context, they decide, I would submit, that it doesn't in fact fall within the true interpretation of the subject matter of the clause. That's where they fell down, is it didn't fall within the subject matter of the clause because the words didn't cover the Grano claim.
At the end of the day, to some extent, it's a matter of, I think it is almost accepted by Lord Justice Morbig in paragraph 14. It's a matter of impression as to what was intended, and there's not a lot of analysis or elaboration, is what Lord Justice Morbig says there. And your point is, really, looking at it broadly, although the strict words would have included Mr. Grano in the Siddiqui case, the court didn't consider that in the context that it was intended to cover an entirely separate investment by a different investor, even if connected. Whereas you're inviting us to say that in the context here, the words do cover these claims, and they should in the context, because the whole purpose of this transaction was to settle the claims, the personal claims of Mr. and Mrs. Riley in the context of RHL, of which they were guarantors, and to allow them to think that the bank would have allowed them To circumvent that by taking an assignment and suing the bank on the assignment would have undermined the whole point of it.
That is my point, my lord. Yes. And there's another difference in the context with the Siddiqui case, which is that one assumes that there was not pre-action correspondence from Mr. Casamini writing to Mr. Siddiqui saying, you owe me, you need to repay my loan and transfer shares to me. And in fact, you need to do the same to Mr. Grano, who has a very good claim as well. And he writes a series of letters making his own complaints and Mr. Grano's complaints. And then there's a settlement agreement.
I'm not entirely sure I've understood the point. The point is in the Barrow correspondence,
Yes.
they were asking, the Rileys were asking for shares to be transferred back to them.
No, the point is that as we'll come to in a minute, the Nabarro correspondence is making claims that are clearly RHL claims. The swap claim, for example, is really only an RHL claim, and that is the background to why the claim was settled, and it is therefore perfectly logical that the bank would say when they're settling the Mr. Riley and Mrs. Riley's direct claims that they also want to settle everything that was being talked about in the pre-action correspondence, which includes...
But I thought we were agreed that on no basis did it settle RHL.
No, I agree, I do agree, but in the sense that they were saying we don't want you, Rileys, ever coming back and making these sorts of arguments again if you somehow can. So if you take an aside, I'm not suggesting that anyone had in mind, at the forefront of their mind, the assignment as the mechanism by which these RHL complaints might come back. But they just wanted to draw a line for the Rileys under any of the complaints set out in the correspondence, which includes RHL type claims. Whereas Mr. Casamini, one assumes, was not making any complaints about Mr. Grano. They were not trying, no one was thinking about settling Mr. Grano's, anything to do with Mr. Grano when they settled this cause of action. It was simply not in anyone's mind anything to do with Mr. Grano. Whereas in our case, the RHL was at the forefront of everyone's mind, factually.
Well, okay. In paragraph 2 of the judgment, the trouble is, as we said earlier, it's a shame we don't have slightly more facts.
Yes.
But at the time of the trial, Mr. Grano had intimated various claims against Mr. Siddiqui. We just don't know.
So his solicitor, well, we don't know, but let us assume his solicitors are writing, saying, Mr. Grano also is complaining, but we can assume, I think, that Mr. Kazemi is not writing, his solicitors aren't writing and saying, we are complaining a bit for Mr. Grano. But yes, we can't speculate. But
to try again, so I'm not saying, but does this amount to this? I think in both these cases, it is accepted that the strict wording is capable of covering the claim. And so at the end of the day, on ordinary principles, having looked at the text, the textual analysis, they cover the claims. Is there a contextual reason to take a different view? The court in Siddiqui said yes, and you're inviting us to say no.
Yes.
And that's really all it can come down to.
It's partly that. I would also say our wording, well, we had a debate about it earlier, our wording, I would say, is stronger because it refers to RHL as well. But so it's partly the wording is different and stronger in our case, partly the context is different and stronger in our case. It's also, clause 7.2 didn't arise in Casamini. Unless I was going to move on from Casamini now.
Yes.
So we say it's irrelevant to a point that Mr. Sims made a few times, that the claims could have been assigned to some third party and that they would have been free to bring the claims is irrelevant in my submission. We are dealing with the situation we're dealing with, which is that did not happen. I gave what an objective bystander might consider to be the reason why the bank took the decision that it was willing to take the risk that no one else was going to take the assignment. And we had various merits points made yesterday. This is not a merits case application. But this case, we would say, is clearly a difficult one for the Rileys. It's not obvious that any third party is going to want to take the risk or have the interest to take this case. But if they did, then we would have to deal with that situation. But the situation your lordships are dealing with is where Mr. Riley is the one who has taken the assignment. As far as the trust point is concerned, we would just make the same points actually that your lordships made to my learned friend yesterday, which was that if we go to the assignment document, which is at tab 12 of the core bundle at page 302, clause 1 has the word absolutely. In other words, the asset has vested absolutely in Mr. Riley. He has legal and beneficial title to it. And the obligation under clause 2 to use the funds recovered in any particular way is no more than a contractual obligation. There's no words creating a trust, some sort of trust arrangement. If he fails to do it, then it will be up to the Duchy of Lancaster to enforce their contractual rights.
Why would they want to do that?
I suppose one hopes that they would be responsible citizens. But
well, I mean, it actually doesn't get. It goes further than that, actually. To answer the last point, the Duchy almost invariably will allow assets of an insolvent company which have vested bona vacantia, if discovered, to be brought back into life, as it were, by restoration of the company. But they'll do so only on terms that the money goes in accordance with the statutory scheme of for distribution. Because the classic situation is just that somebody misses an asset, or an asset just arises when nobody expected it to after the company is dissolved, and the Crown doesn't see it as appropriate that it should retain the benefit, nor that anybody else should get the benefit other than the creditors who should have got the benefit had the asset been discovered in the first place. So, as you say, that's the working out of your phrase, responsible citizens or whatever. They're saying this asset was held on statutory trusts and somebody overlooked it, and it needs to go back into the statutory trusts. But isn't that also why you might say that although there is a tension between the word absolutely at the end of 1 and the agreement in 2, that this is in effect an undertaking to receive a sum of money only on certain terms, and you would resolve that conflict by giving a more limited interpretation of the word absolutely, and giving effect to the clear intent that this asset should not be available for anybody other than that which it should have, those people it should have gone to had the statutory trusts in the insolvency have been properly performed.
And also, we would say that the way that this should be interpreted is that the express word absolutely should be given its true meaning, and the lack of any express wording creating a trust shouldn't override what is expressly there. There's a contractual right. It could be enforced by the Duchy of Lancaster. I suppose a third party might seek to enforce it. If they,
but the context is, the trouble is the context, as I've indicated, is that these were assets on the assumption that there is an asset, right? It's an asset which was held on statutory trusts in the liquidation or administration. So it was an asset held on statutory trusts. The statutory trusts were not given effect to by oversight, accident, or inadvertence. And the Duchy of Lancaster's absolutely universal approach is to say, fine, we'll give you back the asset, but only on terms that you do give effect to the statutory trusts on which it was previously held, before it vested in us bona vacantia. So isn't there every reason to construe this as a trust obligation
effectively giving effect to the statutory trust on which this asset was previously held.
Well, my lord, it would be, if the Duchy of Lancaster wished to do that, it would be perfectly straightforward for them to use the language.
And they normally do. They normally say, restore the company, put it back into the hands of insolvency practitioners, who will then deal with the assets in accordance with the statutory schemes, dispose of them, terminate the liquidation, and get the company struck off again.
Yes.
They normally do that. Absolutely right. I entirely understand that. That is their normal practice. I don't know how this has happened, but again, why wouldn't you interpret this effectively as a slightly shorter circuit, but in essence doing that very self-same thing?
Well, obviously the court can do that, but I would suggest that the proper way to interpret the contract is to start with the words, and if one's used this is a legal-looking formal document where a technical word has been used, absolutely, presumably with intent, and it was terribly straightforward to create a trust, express trust, if that's what was wanted, and it's not been done. But so we would suggest that looking at it's drafted by Farrers. So the court ought to take this sort of drafting at its wording. It's not, although what your lordship says is a perfectly logical thing that they could have done, it's perfectly logical that they wouldn't do that. And so there's no reason to override the express words to achieve a result that your lordship might think would be better, if that's not what they wanted to do. But, my lord, the other point we would make is that it doesn't really matter. Well, if he's holding it on trust, doesn't interfere with the correct construction of the settlement agreement, which doesn't deal with or distinguish between a situation where Mr. Riley is bringing the claim as in one capacity or another capacity. He has just agreed not to bring this sort of claim, whether on his own behalf, on trust for someone else. And indeed, when we say on trust for someone else, it's primarily on trust for the bank and himself and his wife, as it happens. But never mind. This is a question of construction, and even if he is a trustee, he still can't bring the claim, because he said he won't. And he has given a covenant not to sue, and he's released the bank. And so it's neither here nor there as far as the bank's concerned what would happen to the proceeds if Mr. Riley won. That's irrelevant. We just wanted to draw any line under Mr. Riley in any capacity bringing another claim. So it's a bit of a red herring,
Well, your point is that whatever the capacity in which he holds this claim, he holds it, and that falls within the clause.
Yes.
I don't think it was being suggested otherwise. I think the point being made was that because it was held on trust, that in some way that goes to show that the clause couldn't have been intending to apply to this sort of situation. But I'm not sure I really understood where it went to.
Yes,
maybe a very broad merit point that he's in no different position than anybody else who might have taken it on trust. That may be the point.
And we accept that, and we accept that point that Mr. Smith could have taken the assignment and brought the claim, and we wouldn't have this argument. But that is not what happened. As the bank has a lot of experience of these cases, and maybe takes the view that doesn't happen.
Yeah, I mean, your point is that if instead of Mr. Riley approaching the Duchy of Lancaster, somebody else had done so, let's say one of the unsecured creditors, still unpaid, and had asked for the Duchy of Lancaster and had got this document in their name, you'd accept that your settlement agreement wouldn't help you. As a matter of fact, I would still put to you, if Mr. Smith was saying, but I now can bring these proceedings and keep all of the
money for myself, even though I'm only owed a small amount, I'll get a big benefit because I'll keep everything. Faced with this document, I think I'd be putting pretty hard to Mr. Smith. No, you can't. You,
Yes.
Mr. Smith, have promised to do this, and you know, it's more than just a contractual obligation for the reasons I put to you.
Yes, no,
So as my
I
Lord
see
said,
that.
we're not sure where this point actually goes.
No. But equally, in the Mr. Smith case, the bank, as the largest creditor, might say to the Duchy of Lancaster, well, can you enforce your contractual obligation, or indeed assign that to us, and we'll enforce it, or they could try and enforce it under the Third Parties Act. There are a lot of different scenarios, but none of them really assist in my solution. Really, ultimately, what the court, Casamini is an example of a different scenario on the different factual basis of a different clause, and the job for your lordships is to do what the judge below did, and just look at the clause in the context and say, what does it mean here? And we say it is clear on its wording, on the wording of 7.1 and 7.2, that it was intended to stretch sufficiently far that it covers a situation where Mr. Riley has managed to obtain assignment of the RHL claims. And that is the task of your lordships. We say the aim, the obvious aim of both the Rileys and the bank in entering into this clause was to draw a line under any further litigation between them, except arising out of all these facts, except for the enforcing the deed itself. But other than that, they just did not want any further claims, maybe like an assignment of NDA's claims. There's all sorts of claims that could come back to life, and that the aim of the parties was to draw a line under that. And given your lordship's observations earlier, I think we proceed on the basis that on its true construction, this clause covers the claim that is being brought now. Is where we've got to. And so if it's covering this claim, then surely it covers the claim where Mr. Riley is bringing it on assignment. If this clause is wide enough on its true construction to cover this claim, then it should make no difference that the claim is being brought by Mr. Riley on assignment from RHL. So I think that's all I was going to say on ground 5, unless...
Are you going to take us to the bar?
I'm going to, anyway, in the context of limitation, but so I suppose I can feed back some of my points through that process, if that's helpful.
Yep.
So, my lord, unless there was anything further, I will proceed to the documents, which forms part of the limitation argument and feeds into some of what I've been saying on ground 5.
Yes.
So, my lords, can we begin by looking at the particulars of the claim in a bit more detail? I'm not sure we looked at it at all yesterday, or very briefly. Because limitation is to be judged by reference to what the claim is. So the particulars of the claim are at tab 8 of the core bundle. And I think we can pick it up, please, at clause, paragraph 15, which identifies the facilities that the bank provided to RHL, the 600,000 to refund some fees, 3.1 to restructure some existing loans. And then paragraph 16 refers to the £26.5 million loan that was granted to RHL by the bank, the development loan. And there, paragraph 17 mentions something called a cross guarantee, which turns out to be quite important later on, which was a guarantee by NDA in respect of the liabilities incurred by RHL. And then, if we can move forward, please, to paragraph 22, we see that in December 2008, the facilities were replaced by an on-demand loan facility of up to £32 million, which was linked to LIBOR. And the bank, it said, also required RHL to enter into an interest rate swap, which was also LIBOR linked. And then, my lords, we can pick it up at paragraph 25 at the bottom of the page, that in June, or between June and September 2009, the relationship was transferred into the GRG, that's the Global Restructuring Group, and the paragraph 28 refers to an email that Mr. Riley sent in August 2010, where he explained what he understood GRG's function to be, which was to return the accounts to the originating group or business in a satisfactory condition. In other words, he thought the aim of GRG was to take accounts that were having some sort of trouble and to return them back into a satisfactory condition and back to the management of their normal team. Then paragraph 29 pleads in an unparticularised way the alleged oral representations that were made from 2009 onwards as to the role of GRG, which was, it said, people were told it's a turnaround division whose role was to rehabilitate customers. And then this allegation is picked up later with the actual representations relied on. And then, my lords, there's a paragraph 32 at page 121 identifies in a summary form.
So which paragraph?
Sorry, 32.
32.
They say that the bank and GRG did not, in fact, assist the Rileys and RHL, and they identify five things, instances of this. So the first one, number one.
Just out of interest.
I'm sorry.
I mean, 31 at the bottom of the page 120, that the bank was willing to extend and pretend.
Yes.
It's not extend and pretend, it's extend and amend, isn't it?
I think it is extend and pretend, I think is the wording. But it means pretend that you're compliant with your obligations to the bank when you're not.
Restructuring terminology is normally extend and amend.
I see.
It definitely was extend and pretend was the
Really?
phrase used in this
Okay.
case. Yes.
Right, fair enough. All right.
But I don't think it has any malevolent meaning here. It's not pretending to the Rileys. It means let's pretend that you are compliant with your obligations to the bank when in fact you're not. Anyway, so my lord, at paragraph 32, there is the 5 problems they identify. So number 1 is conduct with regard to NDA. Number 2 is various 4 complaints involving RHL, which is revaluation, failure to credit sales, the impact of fees, using and more onerous or unworkable terms. And then the third category of complaint they have is using West Register to acquire the business in a distressed state or at an undervalue. I don't know how much familiarity your lordships have with West Register, but it was a division or a subsidiary of the bank which sometimes acquired properties of customers who were in distress by way of netting off debts that they were owed to the bank. They acquired the property instead, and then they on-sold the property later. And complaint was made by various people that this created a conflict of interest for the bank because they acquired the properties at a non-market price. So the allegation here was number 3 is that the bank intended to use West Register to acquire their business or their properties at an undervalue. The 4th complaint was the distressed sale in administration, and the 5th complaint are subsequent events. And then the following paragraphs of the particulars of claims expand on those 5 complaints that we will just, if I may, briefly run through because, well, your lordships will see why this is relevant later. So paragraphs 33 to 45 deal with the first of the 5 complaints, which is the conduct in relation to NDA. And the main complaint is the failure to release the cross guarantee. And paragraph 43 sets out the most serious allegation in this regard, where it says that NDA was destroyed due to the bank's lack of interest in taking positive steps to restructure RHL and using that as a pressure tactic and or as leverage against the Rileys. So that is the first of the 5 complaints. The second of the 5 complaints are dealt with in paragraphs 46 to 57. Those are the 5 actions involving RHL. The first of those is dealt with in the first few paragraphs, 46 to 51, which is a complaint about a revaluation that a company called King Sturge carried out. We see that they valued, it's paragraph 50, they valued the development at 19 million. And there's a complaint that that was wrong. And then paragraph 48, which we passed, is an important one. It refers to an email which shows, they say, that the bank had a secret intention, unknown to the Rileys at the time. The bank, or GRG, was considering putting RHL into administration. And they rely on an email dated 1st of December 2009. And then at paragraph 49, they say they didn't have sight of this email until October 2010, which comes in as an important, obviously, on a limitation grounds, as I'll develop further. So that's then paragraph 51 alleges that GRG used that low valuation as leverage to drive the Rileys and RHL towards new heads of terms, which were not acceptable. And then at paragraph 52, there's a complaint, the second complaint they make is that there was a failure to credit £2.3 million of sales to RHL for a period of time because they were selling some of the flats in the development they were making. Paragraph 54 deals with the third sub-issue, which was that they say that GRG was loading the company with fees and charges.
I mean, 52 is just a timing. It's well, just 52 is a timing
Yes.
point.
Yes, it said that we held back some sales in order. Well, I think their suggestion is this was done as a way of creating leverage. Again.
I'm presuming the proceeds were held in the securities realisation account, were they?
Yes. So paragraph 54 is an important one, my lords, because it refers to an email from Mr. Riley to Mr. Smith, who was the relationship manager in GRG, where Mr. Riley complained that the bank was loading the company with fees and charges, and that GRG was more interested in short-term paper profit than achieving repayment of the debt, which he said was contrary to your stated objectives. The return to satisfactory point. So here we are in August 2010, and Mr. Riley is making this allegation. The fourth sub-issue was actually dealt with in the preceding paragraph at paragraph 53, which was about providing heads of terms to refinance which were unacceptable. That is the complaint that they make. And then paragraph 56 says that the bank was guilty of applying excessive and unreasonable pressure to RHL in terms of its negotiations, and refers to what's called an unpleasant conversation between Mrs. Riley and Mr. Smith, who is the relationship manager. So that's the second of their 5 complaints. The third issue is the West Register one, which is pleaded in the next section, starting at paragraph 58 and running through to paragraph 73. And in short, it's alleged there that the bank intended to use West Register to acquire the business in a distressed state at an undervalue. And at paragraph 67, there is an inference that, contrary to its open position, it's inferred the bank did intend to place the development with West Register and wished to take advantage of the fact that the Rileys had invested a lot of money from NDA into River Crescent. And paragraph 72 alleges that the bank used pressure tactics.
Just what's the basis of the inference in 67? I mean, you may not be able to answer that question.
I don't think that...
It's not your pleading. I mean, is it,
there's no pleaded basis for the inference.
or is it the previous sentence at the end of 66?
Well, if since it's linked to the exit, paragraph 67, in fairness, sits slightly outside this narrative is mainly contemporaneous, but paragraph 67, you see at the end, refers to exit. So it's not intended to be freestanding, it's intended to be in the context of the exit allegations. You see right at the end, it refers to before exit. I'd accept that needs to be read with the exit allegations. It's not a...
Okay.
Yeah, thank you. So paragraph 72 summarises all that as saying that there were pressure tactics, repeated attempts made to acquire property and secure profits for GRG and West Register. So that's the third of the 5 complaints. The fourth one is dealt with at paragraph 74 to 78, which are complaints about RHL's entry into administration. And paragraph 76 alleges that the bank did that because the Rileys were unwilling to sign up to a consensual transfer and agree heads of terms with the bank. And paragraph... Yeah. And then I think the final complaint that is made of the 5 is dealt with at paragraph 79 to 81, with the so-called subsequent events, which proves to be essentially entry into the settlement deed. And so those are the main factual elements of the Rileys' claim. And it will be noted that the core non-core designation, which is the linchpin of their arguments on limitation, doesn't feature in any of that. Their assessment was that the bank was focused on fees and charges rather than wanting to return their account to mainstream banking. And the alleged early secret intention of the bank was to put RHL into administration, and not referring in any way to the non-core situation. It's just that the bank wished to run up fees and charges, was their case, and profit from the relationship before exiting. Then paragraphs 82 onwards of the pleading, 82 to 93, set out what's described as the internal position of the bank and the non-core designation. And this includes various extracts from the Promontory report, which we will come to look at in a bit. And at paragraph 84, there is an inference, further and in particular, the following passage in the Promontory report supports an inference that RHL had been designated non-core. So their case doesn't depend on actual knowledge of RHL's actual designation, but simply an inference as to whether or not it was designated non-core. Paragraph 86 pleads various documents that they say they only became aware of on the 10th of October 2016. We see that date is in paragraph 85. So 85, they became aware of some documents on 10th of October 2016, which they set out then, or summarise some parts of in paragraph 86. These are where I guess they're saying that they finally realised what was going on. So paragraph 86A refers to a document which showed that GRG was treated as a profit centre. Paragraph B is some document which refers to West Register as being a vehicle used by GRG to acquire property assets from distressed situations, where it's determined it's the best course of action to maximise the bank's ultimate recovery. Then there's a reference to the West Register manual and mission statement, which essentially makes the same point. Then they refer at paragraph D to a statement by the FCA in relation to the promontory report, which included a suggestion that there had been inappropriate treatment that was widespread, as your lordships see there. Paragraph E refers to a final summary report published by the FCA, which found there had been widespread inappropriate treatment of SME customers, some of which was systematic. And then they refer to the fact that in February 18, various copies of the promontory report were in fact leaked. And they summarise what they say is the effects of that report there. And then, my lords, at paragraph 87, they say that it was not until the Rileys read the FCA report in 2018 that they realised RHL had, in all likelihood, been designated as a non-core customer. That's when they say the penny dropped on that.
Sorry, the FCA report.
Yeah.
Yes, it should refer to the promontory report.
It's the promontory report.
Yes, that's what they're referring to.
Yeah.
I think that's a shorthand. It's commissioned by the FCA.
Yes.
Yes, because the FCA made a statement in 2016 about the promontory report.
Yes.
Yeah, but this is actually, yeah, okay, so it should be promontory.
And then paragraph 88, please, what they say are the true intentions of GRG. And they say the primary function, they infer the primary functions of GRG were, one, to implement a 5-year exit plan for non-core customers in particular, by various means, and two, pending that exit, to submit customers to artificial distress by leveraging the covenants. Number three, and pending exit and using that leverage to generate profits for GRG and RBS, get assets transferred to West Register and stifle complaints. So that is their case as to the true intentions of GRG. Obviously, my lord, we don't accept any of this, but that goes without saying. But for these purposes, that is their allegation. Paragraph 93 feeds what it infers were their true objectives in relation to them, as a matter of specifically with regard to RHL, which was the true reason to transfer RHL was to extract the greatest possible value or additional value for the bank from the assets of RHL.
So where are you reading from now?
I'm sorry, 93. So this is what they say were the true motives with regard to them specifically, which was to try and extract the greatest possible value for the bank from the assets of RHL before exit, and or obtain from the bank those assets for its own benefit as cheaply as possible.
Mr. Sinclair, you're taking us through this long pleading and
Yes.
you're reading quite a lot of it aloud.
I'm sorry.
I'm not sure that it's the
That not
best
helpful?
use of time.
No, okay. Well, I've very nearly finished it as it happened. But so, my lords, that is what they say were the true intentions of GRG with regard to RHL. And there are three particular points to note about that, we would say. Firstly, that the GRG objectives here are not focused on exit, meaning having an exit strategy. They're all focused on what the bank was trying to extract value and profit before exit. they say it was really trying to extract as much from RHL before exit. Secondly, well, I think that's the main point I'd make there. So my lord, we then get onto their pleading of deceit, which is in the next paragraph, paragraph 94, are the 4 representations that they rely on. And your lordship see them there. The first is that it was represented that GRG would act as a turnaround division, broadly. Secondly, that the bank would support RHL. And then thirdly, it was said that there were specific reassurances that they wouldn't put the property into West Register. And then fourthly, there were some assurances about whether Clegg, who your lordships will remember is the developer, would be paid, or enough money would be made available for Clegg to be paid. So those are the 4 representations on which this case depends. And falsity then is dealt with at paragraph 95, where it's alleged in paragraph A, the first and second representations are taken together, and it's said that, in fact, the true intention of GRG was not to support the bank, not to support the customer, but was instead to create leverage in order to make profits prior to exit. And various other particulars of falsity are set out there. Paragraph 95A, Roman 4, sets out 7 facts and matters said to support the inferences that are pleaded, which your lordship sees there. The third representation, falsity, is dealt with on page 137, letter B, which relies on 2 of the previous inferences, E and F. So that in other words, the case that the true intention was to transfer the assets into West Register.
I hesitate to interrupt. My learned friend is misreading parts of the pleading. I will reply in due course. But
the third representation was false, as the bank's intention was to put RHL into West Register. Insofar as necessary, the matters stated in A above are repeated, and in particular, the matters pleaded in E and F above are repeated. Which is, I think, what I said, but if it was in particular, was the words my learned friend is emphasising. But the main point they rely on is E and F. And then the fourth representation, which is the one about paying Clegg, they say that's false because they infer, although again they don't plead the basis for this inference, that credit had not in fact been agreed to release funds to pay Clegg, and there was no intention to release funds to pay Clegg. Instead they wanted to create leverage and distress them so as to enable to generate more profits. So and then dishonesty is dealt with in paragraph 96 to 97. If we look at paragraph 97, it contains a series of 12 facts and matters said to support the inference of dishonesty. Only 4 of them relate to the non-core core designation, that's B and C, and G and H. As for the rest, they say, rely on various other matters, that D they rely on the fact that GRG's true objective was to gain and use leverage to generate profits prior to exit. E, they rely on what they say was West Register's intention to obtain profits, acquire profits by acquiring distressed assets. F says because the conduct of the bank was characteristic of what's set out in the promontory report. I refers to the bank's generally dishonest and commercially immoral practices that they identified, for example, insisting on the cross guarantee and heads of terms that were not satisfactory. J involves a particular individual, Mr. Gary Lewis, who they say was wrongly described. Then K is an important one in our submission. It alleges that the bank's behaviour was frequently unreasonable, irrational and unpredictable, and is only readily explicable if the bank wished to distress the companies with the view to making profit and to exit a relationship rather than support RHL. So they're relying on the behaviour they experienced, their contemporaneous behaviour of the bank, of which they were obviously aware, as being only consistent with the desire of the bank to distress and profit RHL and exit, rather than support RHL. L relies on the failure by Mr. Holdsworth to release funds to RHL to pay Clegg, which is said they infer was deliberate. M talks about the desire of Mr. Smith to try to improve, they think that they were trying to improve the value of the assets so that when West Register acquired them, they would be more valuable.
I have to echo what my lord said to you a few minutes ago. We're very used to reading.
We've really slowed to a crawl, Mr. Sinclair. We were rather hoping that you would finish by lunchtime today because Mr. Sims hasn't had a chance to say anything about limitation.
I'm sorry. Okay, I noted.
We haven't yet mentioned limitation.
No.
But it's pleaded. It's pleaded at paragraph 102.
Yes, my lords.
And when we identify where you're going, are you going to get there?
I am going to get there. Yes. Just to say why I'm saying all this, because what I'm trying to show your lordships is that when we look at the Nabarro correspondence, very many of the allegations that we're making here are in the Nabarro correspondence as well. And unless your lordships understand what the pleaded case is, you can't compare it to the Nabarro correspondence. So I'm sorry if it's taking time, but I don't know. If your lordships refer me just to say, please read these paragraphs, and I don't say anything, then that's quicker. But in my submission, the only way to analyse the limitation is to see what their case is that's pleaded and what they knew before the date of the relevant limitation date.
Yes, of course.
And so one has to look at the pleaded case and the pre-limitation correspondence. And I'm sorry if it's taking time. It's partly because it's a very long pleading. It's not my pleading. So I've got to the end as it happens. And I will try and be quicker. So I do apologise. Just look at. Oh, right, in fact, that's right. So 102 to 104 deals with limitations, the Lord said, and they say it's the fact that was concealed was the designation of non-core. So the questions for your lordship really are two when it comes to limitation. Does the designation of non-core versus core, is that a necessary ingredient of the causes of action? Or did they have enough prior to the limitation date to plead their pleading without the non-core core designation? And the second question is, could they in fact have found out the non-core core designation earlier than they say they did? But the first one is sufficient. In our submission is clear, and from my tedious run through of the pleading that, in fact, and as we'll see later, the core non-core is a part of the story, but it's not the key to their case, and it's not a necessary part of their case, which deals with the bank's intention to take fees and charges and distress the company prior to exit, whereas the core non-core point is a different one, which is the bank had a secret agenda to bring about exit as soon as possible rather than return to mainstream. So, my lords, with that, we can look quickly at the Nabarro correspondence, and I hope to do that much quicker. That is to be found in the supplementary bundle. Behind, starting at tab 17. Is the 1st of February letter. And the point to make about the 3 letters I'm going to show your lordships is none of these refer to core non-core, because the Rileys say they didn't know about core non-core at this stage. But what they do at page 256 is the first one, is set out, they say that they represent Mr. and Mrs. Riley in NDA, but they say that they are setting out their complaints about the treatment by the bank. So then, if your lordships can turn forward, please, to paragraph 2.1. In the 3rd line, one of their complaints is that as a direct consequence of the bank's actions, the value in the RHL has been decimated. And then they set out a list of complaints. So the paragraphs 3.1 to 3.14 set out the complaint about the cross guarantee, which, as your lordships may remember, was one of the issues in the particulars of claim. It bears a very close resemblance, these allegations, to paragraphs 33 to 45 of the particulars of claim that I showed your lordships, almost word for word in places. Paragraph 4 of the letter deals with the difficulty of signing the accounts, which is part of the issues in paragraph 42 of the particulars of claim. Paragraph 5 of the letter sets out complaints about the heads of terms, which is again pleaded in very similar terms in paragraphs 53 to 57 of the particulars of claim. For example, paragraph 5.5 refers to the unpleasant conversation that I showed your lordship. That is in paragraph 56 of the particulars of claim. Paragraph 6 of the letter deals with the issue I mentioned regarding receipt of rental income. Then we don't need to worry about 7 and 8, which are minor matters. But paragraph 9 deals with the appointment of the King Sturge valuation, which is the point that was pleaded in the particulars that came at 46 to 50. Section 10 deals with the Tenon proposal, which is in the particulars of claim at paragraph 61. Section 11 deals with placing RHL into administration, which bears very close similarity to the similar allegations in the particulars of claim. And so all of that, my lord, and there is a schedule in Mr. Parr's witness statement which cross-refers between the allegations set out in the Nabarro correspondence and in the particulars of claim, and one sees...
Hang on, sorry.
I'm sorry.
I thought you would... The target you were aiming at is, I thought, the first part of paragraph 103 of the pleading that we looked at. I thought you were going to be showing us, or saying you're going to show us, that the core non-core designation question wasn't essential to the pleading of the cause of action.
Yes.
At the moment, I'm struggling to. You're not really
none of the things that you showed us actually deal with that point. I mean, I thought your point was that the essentially whether it was designated core or non-core was irrelevant to the actual complaint, which is a suppression of value with a view to profit and an exit.
Yes, my lord. Yes. Yes, I am. That is one part of what I'm trying to show. The other part is I'm addressing what they actually knew. I think that was the two aspects. I was saying, what did they actually know prior to the data limitation? Was that sufficient of itself to plead a valid claim against the bank?
I thought the nature of the way it was pleaded was this is what happened
Yes.
at the time. Then what we later found out was this wasn't just misconduct on an ad hoc basis, but was in fact we were completely misled as to the whole shooting match here, because this wasn't just, as it were, bad luck or bad management or a bit of something slightly worse at the time. But right from the outset, the whole purpose of this exercise was to basically strip these assets away from us by wrongfully pressurising us to permit them to do so.
Yes, my lord. And our submission will be that's where we get to in the Navarro, as your lordship may remember, the thinly disguised ploy wording, is that's exactly the point, that they were building up a litany of complaints of what their observed treatment, and says that was it shows that it was a thinly disguised ploy.
But we haven't got there. We haven't got there yet.
It's not in this.
Should we go on to the second matter,
Yes,
which,
so
as
the
I
second-
recall, turns up the temperature bit from the first?
Yes, my lord. Thank you. This continues to make the same sort of allegations that we say factually were set out in the are set out in the particulars of claim. They have a new section at paragraph 4, section 4, making new allegations about the sale of the swap to RHL, which bears on aspects that go to ground 5, which is here is a cause of action which is only really objectively relevant to RHL, a sale, a mis-swap, a mis-sold swap, which was sold only to RHL, and they say it's supported by the significant criticism of the RBS in the FSA review. And then paragraph 4.4 makes a serious allegation of the type that the Lord was talking about before, that RBS was using its leverage arising from the debt in an opportunistic and cavalier fashion to place adverse pressure on them to enter into the swap in order to generate future profit.
Richard Davis, we've seen his name a few times, and he was an officer of RHL, is that right?
I don't know whether he was an employee. Is that right? I'm not sure. But this is exactly the same sort of allegation we say that they have later made.
Is this, my instructions are, he's an accountant, Mr. Davies.
Thank you.
With RHL, not NDA.
My instructions are part-time with RHL. Not with NDA, but I'm not sure. I need to check instructions. Do you want?
I heard Mr. Riley say something different. But never
Did he?
mind. Perhaps you can clarify it.
Group. Oh, group. RHL group. Yeah.
Paragraph, thank you. Paragraph 5.3, last sentence, says the bank didn't approach negotiations in good faith. And then paragraph 5.5 is the thinly disguised ploy point, and is referring to the increasing public concern in relation to West Register.
Well, is it right to say that paragraph 5.5 and the reference to thinly disguised ploy is the high point of your limitation defence?
My lord, no, because they what happens shortly is they bring the Tomlinson report into their complaint, and we'll see that where I think we don't need to go through all of these letters in detail, but that they refer to LIBOR. We can just pick that one up. These in the next letter, 21st of November 2013, at page 275, they point out that there have been various, at the top half of the page, issues about LIBOR, findings by the FSA, wasn't a genuine benchmark. That again is, firstly, it's only an RHL claim. And secondly, it's a claim of deliberate misconduct by the bank.
I'm sorry, forgive me, where are you looking at now?
So it's page 275, in the middle of the page. Do 2 paragraphs there.
But that's only relevant to the swap, isn't it?
There was also a loan that was transferred to LIBOR as well.
Yeah, the swap was designed to... There was a loan that was transferred from base to LIBOR.
Yes.
And that was then coupled with a swap.
That's true. I'm not sure they
The
exactly...
way it's put together is you change your loans from a sterling base rate to LIBOR.
Yes.
And then in order to protect you, we'll sell you a swap.
Yes.
I mean, that's what the objection was. I mean, that's why... I mean, that's where RBS and a number of other banks have been criticised for selling inappropriate swap instruments to customers where they had no need for it and would have been actually better off, frankly, sticking with just the good old-fashioned base rate.
Yes.
Yeah. But that's not... at the moment I'm struggling to understand what relevance that has to the critical point which we've identified in the pleadings of what the claimants say amounted to the concealment for purposes of Section 32.
No, my lord. It's relevant more to the Ground 5 discussion we had, because this is an RHL only claim if they're going to be making a LIBOR claim.
Well, maybe not. I mean,
okay. So then,
sticking to limitations,
yes,
is there anything in Nambare letter number 3 which adds to Nambare letter number 2?
My lord, you would say it's more of the same. Then, my lords, if we look at the letter behind tab 20, which is 30th of December 2013, they say in the 3rd paragraph down, the report issued recently by Lawrence Tomlinson raises numerous concerns about the conduct of the bank, and they say that our client's claim against the bank is a paradigm of the issues identified by Lawrence Tomlinson.
so I'm just trying to... Sorry, give me that reference.
Sorry, it's page 285.
Oh, I see.
And therefore, they claim that their case is a paradigm of the issues identified by Lawrence Tomlinson, which is a reference to the Tomlinson report, which was published in November 2013.
That's mis-selling swaps.
No, not at all. No, that's the misconduct of GRG. Exactly the sort of... Well, I'll show your lordships, if I may. It's not really to do with swaps at all. It's to do with engineering defaults.
Okay.
taking fees. So and that's the document at tab 6 of the bundle, the same bundle, page 72. And if I can in particular invite your lordships just to read the foreword, which is what the one page, page 73.
What was the date of the report?
It was published on the 1st of November 2013 and received by the Rileys that day or the next day.
We haven't actually said so yet. Key date for limitation is October 22. Claim was issued on the 7th of October.
Yes.
The key date is 7th of October 2016.
2016, yes.
For these purposes. Start.
So if your lordships have read the foreword, just to take your lordships to a couple of additional sentences or so in this document. Paragraph 74, between the hole punches, the middle paragraph, last sentence, page 74, these sections of the bank should be turnaround divisions aimed at improving business performance, but the evidence received indicates the opposite. They're being used as profit centres for the bank. Top of page 76, Dr. Tomlinson had various three conclusions as to what he saw was going on.
So it's page 76.
So yes, sorry, page 76, top of page 76, numbers 1, 2 and 3. And then he dealt with West Register at the bottom of page 78. At the last paragraph at the bottom of 78 and the top of 79, he suggests that there was an intention to purposefully distress businesses and take them into West Register. In paragraph 12, sorry, page 83 of the bundle, 3 paragraphs up by the second hole punch, he says that GRG is actually, the evidence suggests GRG is actually designed to be a profit-making centre for the bank and not a turnaround division.
So where's that, sorry?
Page 83 by the second hole punch. It is important.
So that's where that's the allegation that this isn't just something that happened but was designed. This is That's the key word.
Yes. which is essentially what Dr. Tomlinson concluded, in fact, that this was what GRG was designed to be, a profit-taking centre, not a turnaround.
And the message to customers is misleading.
Yes. And they regarded, I think there's a reference to them saying when they read this report, they thought it's autobiographical. They thought it referred to them. I showed your lordship. They wrote to the bank saying they are a paradigm of this. And so...
where is the reference? Where is the reference to autobiographical?
I'll get it's in Mrs. Riley's witness statement. We'll get the reference. So, my lords, we say that as at the November 2013, the material that they had was their own litany of complaints that your lordships have seen, which hasn't changed in the particular claim, all the serious allegations that they experienced, and their view that that was only consistent with the banks having a motive, coupled with the Tomlinson report, which made very colourful allegations of the most serious type, really, against the bank, exactly consistent with the type of allegations they were seeing. And if we then remind ourselves of the misrepresentations relied on, at paragraph 94, the first two were that the GRG was there to act as a turnaround division and to support RHL. They clearly had the knowledge and the material to say that that was false on their case, as at the date of the publication of the Tomlinson report. The autobiographical is paragraph 59.4 of Mrs. Riley's witness statement, supplemental bundle, page 232. And the third misrepresentation, that there was an intention, the promise not to put River Crescent into West Register. They had the material to contradict that, or to infer that that was false. And fourthly, the intention not to pay the Cleggs, likewise, in our submission, that they had a sufficient basis to plead those allegations as at the date of the production of the Tomlinson report, coupled with their own experiences, and the core non-core question of whether the bank actually had some additional intention to exit the relationship that didn't actually add, indeed isn't particularly relevant to those representations, which are all about scalping the customer prior to exit, rather than pursuing an exit. Save, obviously, that part of their point is that there wasn't a genuine intention to rehabilitate. But they had that information from what Tomlinson was saying and what the conduct they had seen. So, my lords, we say that there was sufficient information in Tomlinson, and if one then, and this is to be coupled with Dr. Tomlinson making very vivid allegations in front of the Treasury Select Committee in January 2014, which is in the bundle, page 36, tab 36 of the supplemental bundle. He made if we turn, for example, to page 388, at question 45, he was asked whether TRG was a profit centre in its own right. He said yes. And the question was it 46, incentivised to asset strip them rather than support them? And he says yes, absolutely. And we would refer to a number of answers he gave in questions 61, 85 and 86.
But Mrs. Riley's witness statement refers to the fact that Dr. Tomlinson himself, in a press release, said that his report did not accuse RBS of fraud.
Yes, well, that's true, but one can read the Tomlinson report and see what it does say.
Yeah.
Well, your case isn't that the Tomlinson report told the Rileys that there was a fraud. Your case is that those matters indicated that what had been said to them was false.
Yes.
It provided the falsity and deliberate falsity. That's your argument.
Yes. Then there's that. So that was all information publicly available to the Rileys before the primary limitation date of October 2016. And it's not just publicly available information like the Treasury Select Committee report, but it's information that we know they got, like the Tomlinson report itself. We know they received that and read that because their emails.
Can we just clarify this? You say, I think we just need to be clear what we're talking about here. It seems to me October 2016 isn't the primary limitation date. The primary limitation date is 6 years from the relevant events.
Yes, I'm sorry. Yeah.
And what we're now talking about is the date, we're talking about section 32, and date of knowledge or point at which they could with reasonable diligence have discovered.
So that's right. It's common ground.
The question is, was that satisfied less than 6 years before the proceedings were issued?
Thank you. It's common ground the primary limitation period has expired and they're only arguments on section 32. So
yes.
And so the 6 years, the reason I refer to that date is not correctly called primary limitation.
Well, yeah, I mean, they say the effect of the concealment of what they allege in 103 was to stop the limitation, effectively to stop the limitation period running. And it started, you say, but it started at the latest, let's say at the end of 2013, with the Tomlinson report and the acceptance in the letter of the 30th of December 2013 that the Tomlinson report was basically the paradigm, showed that their case was the paradigm of the issues identified by Tomlinson.
Yes.
So you say at the end of 2013, at the latest, according to that letter, they had identified that what was said to have been the case in Tomlinson was their case. And you say they then, on any view, that meant that they had 6 years to bring their claim from then.
Yes.
So end of 2019.
Yes, exactly.
And
So
therefore, limitation period on any view had expired before proceedings were issued in 2022.
Yes, correct. Thank you. Yes. But because we know when the claim form was issued, the question is what did they know? We can, in fact, take the date forward to 2016, October 2016. So,
well, yeah. I
but
mean,
we
so
don't
what you could say is, and indeed, if there are other material factors that came to light in 2014, 15, and 16,
yes.
or up to October 2016, you make the point as well. But in fact, you say Tomlinson was enough. That's your
Yes,
first.
that is the point, exactly. And in fact, that's when the clock starts ticking. So they then also have 6 years to get on and research it. But
I'm already thinking, what's further is, once it's said that what is said in Tomlinson is they are a paradigm of that, and it's autobiographical. In other words, this is what happened to us. In a sense, the distinction between core and non-core is irrelevant,
yes.
because they knew that they were treated in a way which they later discovered only some people were treated,
Yes.
namely non-core. Is that right? Non-core?
The non-core.
Non-core. And so you say, as they knew they were treated, as they later, I'm saying the same thing again,
Yeah.
as they knew they were treated, as they later found out some people were treated,
Yes.
that distinction is irrelevant.
Yes. And that's what we would say. And also the core non-core provides a motive for the bank's behaviour. That's the point. That they're saying the core non-core distinction means the bank had a motive to get rid of certain types of customer. But it doesn't...
Well, I mean, I think as I understand it, you say that if you go back in Tomlinson to what you told us, what you read quickly to us at the start, and I'll just try and find it again. Very first sentence. It's important to remember that post-crash and bailout, banks needed to remove bad debt from their books, to downsize parts of their portfolio and rid themselves of risky lenders. I mean, that's the context.
Yes.
I mean, you're saying the core as I understand it, the core non-core point is that the bank sort of designated the customers which it wanted to keep as part of its core lending business post the crash.
Yes.
And those customers who were not part of the core lending business, for whatever reason, more risky, inadequate security, different types of business, were designated non-core, i.e.
Yes.
non-core to the bank, and therefore were, as it were, to be dealt with and taken off the books.
Yes. So he doesn't use the technical description core non-core, but he's talking about the same sort of thing. And he is providing a motive for the banks. He says GRG was set up to asset strip and raise fees and so on. But core non-core provides an additional motive in a technical language, which we say isn't crucial to their pleaded case.
Can I ask you? You made the point that the claim that the RHL was designated non-core was an inference.
Yes.
But you pleaded a 84-page defence. Does it anywhere in there? Does it plead whether they were core or non-core?
I think we have confirmed that they were non-core.
So the writing.
But it was a correct inference.
Yes.
The first time it was confirmed was in the defence.
It was in the defence. Yeah.
So that's not in dispute. But the point I'm making on that is they felt able at the time of pleading the case to plead it on the basis of an inference that they could, in fact, if this was such an important point, they could have pleaded that inference early.
Yeah, but they didn't know about the distinction between core and non-core.
I haven't taken your lordship to the material in the public domain, which shows that the core non-core was not a secret. They say they didn't themselves know about it, and let's assume that's true. But it was a publicly known fact.
But that's the question we're looking at, isn't it? Is what they knew, unless you're going to say they could reasonably...
Well, the reasonable diligence is, yes, exactly. So it's what they knew or with reasonable diligence could find out.
So are you saying that although they didn't know, they could with reasonable diligence?
Well, that's my second prong of my argument. My first prong, and maybe the easier prong, is they don't actually need that information to plead their case. But the second prong is they could, with reasonable diligence, have found it out from the public documents that we've referred to in our skeleton, which were the bank's annual report and treasury report and so on, that explain there was a bad bank, a non-core division had been set up, that commercial real estate formed a very large proportion of it, and which was their category. And we say that they could have formed that same inference from that information anyway. But the primary point we made.
But is the test could or should reason? I mean, what do you say the test is? Because I mean, if there are a number of points that a suitably skilled detective could have put together to reach a result, that's not enough. What is somebody's trying to get your attention behind?
Yes, I mean I think that there's a suggestion that someone who is motivated to bring or investigate a claim has to carry out a reasonable.
The test is could with reasonable diligence.
Exactly. It's could with reasonable diligence, and it's a person bringing a claim.
Right, but it's
what should they do?
So
what could they do?
It's not could if they'd have been really, really on the ball and highly skilled to put two and two together.
Yes, certainly not.
And neither is it would inevitably if it's could with reasonable diligence.
Yes, if they set about with reasonable diligence, looking, could they have found this? Could they have
Well, there's
found
quite a
this
bit of law on this, isn't there?
There is law on this, and I think it's in our dealt with in our skeleton. That I can,
It's also quite, I mean, to some extent, it's quite a fact-sensitive inquiry, isn't it? As to what, with reasonable diligence, the person at the time could have put together to reach a particular conclusion.
I suppose it could be. It would depend on the situation where.
Well, at this stage, don't you have to show it's actually you either have to show actually this core non-core is irrelevant, which is your first point. They could have pleaded the case without reference to core non-core because they had enough to plead the they knew they'd been misrepresented too because of what was said in Tomlinson. So core non-core is just icing on the cake. It's not a critical part of the case. That's your first point, as I understand it.
Yes.
Your second point is even if core non-core is a central part of the case, actually you could have figured it out with reasonable diligence.
Yes, that is the second limb of our case, and the basis for it are the documents we've referred to in our skeleton. It's probably not the best use of my time to take you to them, but there are public documents. The bank's annual report, you would think, it doesn't know factual inquiry is required to show that someone with reasonable diligence should look at the bank's annual report.
Do you want to show us how quickly you could have done it then?
Sorry?
Show us it.
Yes, I will do so. Okay, then it is. Let me just find it. Sorry. Yeah, let me find that. Yes, it's supplemental bundle, page 42. So, well, it starts at page 40 is the annual report for 2009. Page 42, the first substantive page. First page, about 6 paragraphs down. We are delivering our strategic plan and risk reduction non-core runoff. And the box on page 43, about 10 boxes down, exit non-core business lines, which is then expanded on at this isn't the whole annual report, but so page 45 is page 40 of the annual report, which has an explanation about the non-core provision. And it is made very clear, my lords, from the document, well, we say it's very clear from the document in the next tab, which was a document produced by the HM Treasury, which had various paragraphs dealing with core, non-core. But if we just go to page 68, there was a pie chart showing that commercial real estate loans, 47% of the non-core assets were in the commercial real estate loan business, which is the category they fell into. But we've given more references in the bundle. We say it was apparent from these sorts of public documents that anyone exercising reasonable diligence could have discovered the core non-core distinction. And we're not saying that they would have known that they themselves were. Obviously, that wasn't a published fact, but they could have inferred that they were based on the fact that they were within the commercial real estate loan portfolio, which formed a very large, substantial portion of the non-core division, coupled with the behaviour that they say that they experienced.
Well, and they were represented by Nabarro Nathanson.
Yes, indeed.
Do you think might have looked at the bank's documentation when writing to the bank?
Well, if exercising reasonable diligence, that these would be fairly key documents to look at, my lords. Can I take your lordships to look very briefly at the promontory report?
Sinclair, unless you're about to show us some remarkable smoking gun, I think the way I see it, speaking for myself, is this. If you succeed in establishing the limitation defence on the basis of the Tomlinson report and other facts known to Mr. and Mrs. Riley at the end of 2013, you don't need this.
No.
But if that limitation defence doesn't succeed,
Yes.
then the judge said that if, I appreciate he was against your limitation,
Yes.
but one paragraph of his judgment says that if you get to the stage of looking at what the Rileys could with reasonable diligence have discovered
Yes.
after 2013, but,
Yes.
then that would need a much deeper examination of the facts than was appropriate at summary judgment.
Well, I hear your lordship, and so most of my fire is aimed at the first limb of my argument, which is what they actually knew. Yes, I take on board. Well, look, can I show your lordships the promontory report, which is at tab 8? The reason I want to show it to you, it's at page 95 of the bundle. It was published in 2018, so it's after the date. But it is the document they say the scales fell from their eyes. Mm-hmm. And the reason I show it to your lordship is because the promontory report actually debunked most of Tomlinson. And the conclusion of promontory was, in fact, many of the allegations that Dr. Tomlinson said were wrong or exaggerated or not found. And therefore, although the promontory report revealed the core non-core, the high watermark of their confidence in their case should have been on publication of Tomlinson. And if anything, the publication of promontory should have made them more doubtful about their claim. And I take it as briefly as I can.
Okay,
I think we've set out the
tab?
references. I'm sorry, it's tab 8
Tab 8, thank you.
of the supplemental bundle. It starts at page 95. As I say, the date of it is 2018.
It's dated 2016. It came to my client's attention in 2018.
Thank
It
you.
wasn't published in 2018.
I'm grateful
Dated
for that. Yes.
2016.
As far as the Rileys are concerned, the date's 2018. I'm grateful.
So it's 2016, but published in 2018.
Internally, it was produced in 2016. Didn't enter the public domain until 2018. It was leaked in February 2018.
And your lordships will see in the foreword at page 97, a paragraph Roman 2, that one of the specific things they were asked to look at was the validity of the allegations made by Tomlinson.
So where's that?
So it's Roman 2 on page 97. And there we can see their primary conclusions at page 98, at Romans 8, 9 and 10. And then if we pick that in more detail, please, at page 100, to see where they agreed with Tomlinson, is at paragraphs 1.4 and 1.5. But then, if your lordships are there, at paragraph 1.9, this is where they disagreed with some of the more serious allegations that Dr. Tomlinson had found. So, and there's a lot more detail in Promontory, some of which we have referred to in our skeleton, but the upshot is, in our submission, that Promontory report did not support their case that the GRG objectives were what they say they were, to artificially distress customers. And never return customers to mainstream. The GRG found that, Promontory found that 84% of customers were not inappropriately treated or were not caused material financial distress by GRG. And Promontory found that customers were not being artificially transferred into GRG in order to generate fees and so on, which was at the core of their complaint.
What's BRG?
That's the business. Yes, it's a division of GRG. I'm not sure exactly what the.
So is the reference to? I mean, you said you're going to show. Where's the reference to non-core? That's 116, is it?
So yes, the reference to one core, non-core is 1.16 exactly. Yeah. I think there are maybe a couple of others in there as well. So, yeah.
But that you say just reflects what you showed us in the annual report for 2009.
Yes. But also, can I show your lordships one last document before I get on to submissions, which is paragraph, the next tab, tab 9, which is the letter. Page 156.
Before you leave it,
I'm sorry.
I think it's put so much at the heart of the case that I think we really do need to understand where this refers to non-core. Is it just 1.16?
It's not, my lord. No, there are various other references which I'll take your lordships to in reply. But we can go to them now if you want. To assist your lordships in our skeleton argument, our supplemental skeleton argument, we've compiled a list, and if we turn to that, remember it's footnote 4. Footnote 4, page 350 of the bundle, so it's behind. From memory, the supplemental skeleton fuss is near the back of the core. So it's tab 17, page 350.
There's probably the best reference is page 136 at paragraphs 4.3.6 to 12.
All right, we'll just read that page in a bit to ourselves. Right, thank you.
Yes, can I please take us to the next tab, tab 9, at page 156, which is a letter from the Riley new solicitors sent after they had read the promontory report. We know that because they say that in the penultimate paragraph on that page, which sets out a litany of complaints again, but these are broadly the same, or a subset of the same complaints the borrowers were making. And if we pick it up, please, at page 164, paragraphs 2.2 and 2.3, they make some allegations against the bank. This letter doesn't refer at all to core, non-core. So it makes all sorts of allegations that they want to make, having now read the promontory report, but they don't feel the necessity to refer to the core, non-core distinction. They allege at paragraph 2.2 that evidence is now available post the settlement agreement to substantiate their claims, and that they want to set it aside if they have to. At 2.3, they still are hanging on to the Tomlinson report. Not surprisingly, we say, because that's far more supportive of their case than is promontory. But we say this is an important letter in terms of assessing whether or not the non-core points were essential to their claims or were necessary before they could plead a claim in fraud. Because the fact that they're saying they can set aside the agreement on the basis of Haywood and Zurich, which they say at 3.1, means that they are saying this is a fraud claim. Yet they feel able to substantiate a fraud claim without reference to core, non-core, even when the scales have fallen.
Just to understand this, you're saying that this letter does not make the core, non-core point.
Yes.
So, I mean, what you're saying is that the emphasis on core, non-core is basically designed to overcome a limitation defence. And in fact, when you look at what was actually being said at the relevant time for limitation purposes, the claim was perfectly capable of being brought without reference to core, non-core. Because the essence of the claim is, far from being taking us under your wing and restoring us to value and returning us to the mainstream bank, you were in fact intent on stripping value out of the company for your own benefit, and critically, that was the misrepresentation on which the claim could and should have been brought. That's the key representation, and that the core, non-core is just a bit of icing on the cake, which wasn't fundamental to the bringing of the misrep claim.
Exactly, yeah. Yeah, that's our case, and thank you. And it's spelled out, we say, made clear by this letter from De Bello.
When did they first put their case on the basis of core, non-core?
That's in the first document in the bundle, anyway, is the one at the next tab, which was a letter in November 2021 from De Bello, which does now make the core, non-core complaints. Yes, what was? I think it's page 173 of the letter. Yes, 56 and 57. Yes, so 56 says that they now have some additional strands to their complaints, which they hadn't mentioned before. That's the second line of page 56, some additional strands, and then 57 is one of these strands, is the call on court. So, my Lord, having gone through those documents, just to address my submissions on limitation, then there's a preliminary point that my learned friends make. I don't know whether they're sustaining it now, which is that they suggest that the judge's decision on limitation was a case management decision, and therefore subject to the rules on appealing against case management decisions, rather than a substantive decision. And they rely for that proposition on a case called Allied Fort, which is in the authorities bundle at tab 20. And in particular, paragraphs 100 to 102.
Sorry, I misheard.
I'm sorry, it's tab 20.
Tab 20, I'm sorry.
It's page 743 of the continual pagination. And it's paragraphs 100 to 102.
This is fairly familiar territory, isn't it? And there's nothing remarkable about paragraphs to which you've drawn our attention.
No, I think that the suggestion my learned friends make is that if a judge grants summary judgment, then one can appeal in the normal way. But if he refuses it, a defendant's application for reverse summary judgment, then that is a case management decision. That's their argument. But in my submission, that's not what the judge is saying in this. He's dealing with a different situation where a judge decides not to even consider the application for summary judgment for some case management reason, such as it's too close to trial or something like that. So we assume that point is not valid. So this is a normal appeal in the normal way. So in our submission, your lordships have the key dates for limitation purposes. Proceedings were issued on 7th of October 2022. And so, and the relevant date for section 32, therefore, is October 2016. Obviously, we are content to adopt the judge's summary of the law that he gave in this area, which is in paragraph 113 of his judgment, and is probably familiar to your lordships. On the your lordships can have that. It's at page 92 of the core bundle, and the judge referred in paragraph 113 to the principles that he were important. We would, one of them picks up one of the points that I think your lordship was asking about, could with reasonable diligence, is in Roman 5. It's about how it's an objective standard. As we've said in our skeleton, we're content to adopt the statement of claim test at this level, although we not convinced it is in fact the relevant test, but it doesn't matter. We are content to adopt the statement of claim test, which is explained by the judge in paragraph 6, which is the ability of the claimant to plead a viable claim. And in a fraud claim, that's the critical steps or constituents of the cause of action, which are set out there in 6A. But 6B, we would emphasise the points that the learned judge set out there by reference to what Mr. Justice Bryan said, that the question is whether you can plead a complete cause of action, however weak or strong, and you do not need to know every detail, and that a realistic view needs to be taken by the court. And as far as the authorities that he discusses at section C are concerned, that's to do with the special obligations on counsel in terms of pleading fraud, which we obviously accept. But we draw attention to what Lord Bingham said in Medcalf and Mardell, which is set out there. He gives an example where it would be professionally proper for counsel to plead even serious allegations based on conclusions of in that case, a DTI inspector, even though you haven't seen the actual underlying documents. And that has an obvious application where one has the Tomlinson report here. So, in our submission, it's not clear whether or not the appellants accept that there was a trigger in this case, whether they were on notice for the purpose and when that happened. But we say clearly they were on notice of a potential claim when from the Navarro correspondence and from the Tomlinson report was a sufficient trigger. They knew the events to which they themselves had been party. And they knew RHL was at this stage in administration, and they had suffered loss, their own losses. They knew about the Tomlinson report, which was a paradigm. And so the only question is whether they could, with reasonable diligence, have pleaded the claim that the representations were false and fraudulently made by October 2016, given that there was a trigger. We say that the Tomlinson report was sufficient. It accused the bank of using GRG as a profit centre, of West Register being wrongly used, and so on. And that was sufficient to plead that the representations that were made were false, and that the true agenda, if one looks at the particulars of claim, paragraphs 92 to 93, in our submission, their case as to what the true agenda of the bank in their case was, in our submission, was pleadable on the basis of what they had experienced, as they allege, and what they could read in the Tomlinson report. And this is what they plead with the GRG objectives. They use the abbreviation GRG objectives, for which they have summarised as the points set out there. But these are all things that the bank was accused of having as its agenda or objective in the Tomlinson report, which was all about the bank deliberately seeking to transfer customers to GRG to extract value from them, including through West Register, to improve its own position at the customer's expense. So they could have pleaded this on the material available, certainly by October 2016, and it can't be said that it was only pleadable on site of the promontory report, which is their case, for the simple reason that, as we saw, as we say, the promontory report concluded that the bank had not transferred customers to GRG in order to extract value, or with a view to West Register purchasing their assets. So the GRG objectives could have been pleaded at any time after the receipt of the Tomlinson report. And if one looks at the particular representations relied on in paragraphs 94, the first two can be taken together and are, in a sense, a representation that GRG will turn around customers, or their function is to turn around customers and return them to mainstream banking. That is something they could have pleaded the representations at any time because they experienced them, but they could have pleaded the falsity of that because they rely on their own experience, which they say was only explicable in this way. And they could have relied on the general observations made in the Tomlinson report. And I showed your lordships before the paragraph 97K on page 139, which in a sense is a summary of their overall case that was available to them, and drew nothing from the promontory report or the core non-core distinction. So
just trying to put this into a legal framework. You're saying that the judge should have granted reverse summary judgment. Yeah. And that's because, absent section 32 applying, everybody would say, understand that limitation had expired. The claimants have the burden of showing that they have a realistically arguable case, or case with a reality about it, that section 32 applied, and that they could not have formulated a viable cause of action prior to the end of October 2016.
yes.
You have to show, I think, and the burden is on you, that they have no realistic prospect of succeeding in that defence.
Correct.
And you say you satisfy that because you can show that they could have pleaded a viable cause of action in deceit prior to that date based upon the Tomlinson report, and that the core non-core distinction that they include is not an essential element of the claim in deceit, but it's an additional strand, or it's something that improves their case, but not an essential element of it. Have I got the framework right?
Thank you, yes.
Right. And you say that the key elements of the case are that by or following receipt of Tomlinson and the digest of it, they must have realised that what they had been told by the people at RBS about the way that they were being treated, i.e. with a view to rehabilitation, had been false. And you say that's good enough to start the clock running. The core non-core designation isn't critical to that.
Yes,
in a sense, the way that they could infer that they were non-core businesses is because of the way they've been treated.
Yes.
And you say that was, and knowing that was enough to know it was false, representations were false.
Well, in fact, they don't even need that, as in because they could just say, even ignoring non-core core, they could just say that the simple Tomlinson view of the world is that the bank was trying to scalp customers. That's what its aim was, to scalp customers and not to rehabilitate them.
Yes.
Just out of pure venality.
Yeah.
And the non-core provides a sort of fig leaf for saying, well, they were doing it for good economic reasons. But in a sense, it doesn't matter whether they were doing it for pure venality or for good economic reasons. Either way, they were doing it for wrong and lying about it when they said they weren't.
And you say, as a matter of fact, somebody in the position of the claimants having access to competent law firms, very competent law firms, would also have checked the 2009 or subsequent annual reports, which showed that after the collapse, RBS was put onto a track which involved ridding itself of non-core business.
Yes, exactly. So Tomlin,
you could, with reasonable diligence, have deduced that if contrary to your first point, core non-core was a critical component of the case.
yes,
You could have in fact deduced that with reasonable diligence, because you would have looked just simply at what RBS said it was doing post 2009.
yes, because the promontory report had a bit more detail on it. It's obviously it didn't say the Rileys you're non-core, so they've still had to infer it.
But in fact, the promontory report referred you back as we saw it in relation to that to what RBS decided to do in 2009.
Yes.
Yeah, right.
Yes, my lord, I'm very close to the end. I'm sorry that it's taken a bit longer. If I may have a short time after lunch.
How much longer do you need?
If I had half an hour, would that be acceptable?
I think that's too long.
Okay.
I mean, we did. We cut away the need for you to respond on grounds 1 to 4, leaving just 2 points.
Yes.
Speaking for myself, I thought you were about to look at your notes and say that you'd covered the ground, but can you look at your notes over the lunch hour and see whether you can wind up within 10 minutes?
We'll do that. Now, are we going to be back here or somewhere?
Oh,
else?
that's a good point. Oh, right. Lord Justice Phillips has had a message from the High Command saying that the chillers have failed all over East Block, so perhaps we'd better just stay where we are. And then whoever's watching on...
I think actually it does feel a bit cooler now.
it does feel a bit
better.
a bit better.
Because we've opened the door.
Or was the chiller working again?
Or maybe the chiller's away. All right. Well, look, we'll stay put, and we'll resume at 2 o'clock.
All right, okay.